Hello everyone, welcome to City Futures Research Centre seminar series. I'd like to acknowledge that we're meeting today under the traditional lens of the Gadigal people of the Eora Nation. I'd like to pay my respect to the elders past and present, as well as any First Nation people joining us today. If you're joining online, please mute your microphones and turn off your cameras. Once we get to Q&A, you're welcome to turn them back on or put your questions in the question box. So today, it's my pleasure to introduce Dr. Chris Martin, who is a Science Shepherd Senior Research Fellow and co-lead of the housing program in the City Futures Research Centre. Chris's research interests are in the rental housing and housing policy, with a special interest in tenancy law. Chris has led and participated in numerous inquiries and research projects, including a Hurry's Future of Private Rental Inquiry and Regulation of Residential Tenancies and Impact on Investment Project, and current ARC project on rental vulnerability in Australia and evictions. Before joining City Futures, Chris was a Senior Policy Officer at the Tenants Union of New South Wales and the past Chair of Shelter New South Wales. Today, Chris is going to talk about Gough Whitlam, Australian Prime Minister who had a pre-parliamentary career as a barrister, specializing in landlord tenant cases. So in this seminar traces Whitlam's tenancy law career, illustrating some significant aspects of the development of Australian tenancy law and changes in the professional status of tenancy law practitioners. Please welcome Chris.
Thanks, Barry, and thanks for that introduction. You may have noticed last week on the 11th of November, the nation observed a significant anniversary. It was the 50th anniversary of the infamous dismissal of the Whitlam government by the Governor General, Sir John Kerr. There was another 50th anniversary a couple of weeks before that went unremarked, but we'll touch on it in today's seminar. The Whitlam government is remembered as the most activist, reformist government in Australia's history. But less well remembered is Gough Whitlam's own prior career as tenancy lawyer. That's what we're talking about today. So before he entered Parliament, it was a barrister specialising in landlord tenant cases. This experience, I'm not going to claim this experience was formative of the man or his politics or his prime ministership, but I think by tracing Whitlam's career in tenancy law, both before Parliament and a couple of encounters with tenancy law afterwards, we do get an interesting insight into how tenancy law in Australia has developed through the period of rent control and then decontrol and then the Residential Tenancies Acts, and also the changing status of tenancy law practitioners. So, for an outline of today's seminar, we'll divide it up into Whitlam's legal practice, an episode when he was in Parliament as an opposition member, and then Whitlam in government, and then some concluding remarks. So, in practice, Whitlam was admitted to the bar in New South Wales in 1947. He'd studied law at Sydney University. Those studies were interrupted by his service in the Second World War in the Air Force, and he went back, finished his degree, and then was admitted as a barrister in 1947. He took briefs as he was building his practice. He took briefs from the Legal Service Bureau, which was the first government-funded legal assistance program established during the Second World War, particularly for service people and veterans. So he built his practice out of Legal Service Bureau referrals, which might reflect the tenancy law focus, but also tenancy law was productive of work for barristers at this time. So in 1947, when he first started out as a barrister, tenancy law was property law as we'd received it from England, modified by piecemeal statutory amendments, and the most significant of which in 47 was national security landlord and tenant regulations. And then a year later, those regulations, those national regulations, were allowed to expire, and the states took back landlord-tenant regulation. They reenacted that national legislation, reenacted it, and then all went and did their own separate things with it. Tenancy law was very productive as legal practice at this time. It's remarkable how much the law reports are full of tenancy cases going before the New South Wales Supreme Court. So looking just at Whitlam, there's 11 reported cases in the weekly reports and the state reports between 47 and 56. When Whitlam was practicing, 11 reported cases where Whitlam appears in a tenancy case in the New South Wales Supreme Court, and there's another 2 in the High Court case. 8 are residential tenancies, 4 for landlords, 4 for tenants. At this time, residential tenancy law and commercial tenancy law were a lot closer together than they are now. That's one of the themes of this, of the account I'm getting today. So we're going to, today, I'll cover 3 cases from this lot. 3 cases that illustrate features of particularly the New South Wales law, the 1948 Act, that reenacted rent and eviction controls, and also the complex entanglements that the law had with the common law of property. So, first feature of the law, and the first case we'll talk about, concerns fair rents. This is how we controlled rents in New South Wales in the post-war period. So the case we'll talk about is called Owen and Woolworths Properties. In this case, Whitlam represented the landlord being Woolworths. It owned a building. Its building in the CBD was then on the corner of Market and Pitt Street. That's the Pitt Street Mall there in the photo. You can see Woolworths at the end. And the tenant, this is a commercial tenancy case. The tenant was a shop owner who sold luggage in the building. And the case, the decision itself has a neat account of how fair rents were determined at the time. And that method was known as the basic rent plus method. That was the approach to setting rents. Either party, a landlord or a tenant, could apply to the Fair Rents Board, which was constituted by a magistrate, and seek a determination of what the fair rent was for the property of which they had a tenancy. And the basic rent plus approach was to find out what was the rent at the 31st of August 1939, and if that was a bit low, for whatever reason, the landlord had discounted or something, they could bump it up a bit. That was the basic rent, and then adjust that up again for the difference between the landlord's outgoings, maintenance rates, insurance, water, tradesperson's wages in 1939, and what those outgoings were now, adjusted up for the difference. And then also make an allowance, which was equivalent to 0.05% of the capital value of the premises at the 31st of August 1930. That's how we did rents in commercial and in residential as well. So in this case, the landlord, Woolworths, had actually gotten what it thought was quite a good fair rents determination out of out of the Fair Rents Board. And the tenant was appealing to the Supreme Court, saying that the magistrate got it wrong. In particular, they had not considered the effect on the outgoings of the abolition of land tax at the federal level, and that the magistrate had erroneously included land value in the capital value of the property at 1939 when they were doing the 0.5% allowance. So this landlord had gotten quite a good fair rents order from their point of view. The Supreme Court, when it heard the tenant's appeal, held no, that order is wrong, but not for the reasons that the tenant wanted. They said, no, in fact, in commercial tenancies, this working out the basic rent in 19, you don't need to do that. You have the Fair Rents Board have a wider discretion about what you consider and what the fair rent should be. And so both parties didn't like that order, and so appealed to the High Court. And the High Court held, no, you can't do this discretion thing. It wasn't brought up earlier. The fair rents order made by the magistrate stays in place. This upsetting the order with this new argument about how much discretion the magistrate really had won't be allowed at this stage. So Whitlam's client, Woolworths, got to keep this fair rents order that it liked, which was happy for them. But the main significance of the decision was that this was signalling judicial discontent with the fair rents regime, that the basic rent plus method was judges at the Supreme Court and the High Court, for that matter, weren't that happy with it. And it foreshadowed an even bigger challenge to rent control that subsequently came in 1964, the mid-60s, in a residential case called Rathbone and Abel, where the High Court then decided, yeah, this wide discretion as to what a fair rent should be. There is a wide discretion. It's for commercial, it's for private residential as well, and it really would have upset the whole way that rents were regulated. In particular, the High Court said the current capital value, forget about 1939, the current capital value should be a consideration in what the rent now should be, which would have allowed much higher rent increases and really upset the regulation of rents. In response to that decision, the New South Wales Parliament made a patch repair, and at the time, as it did so, the Minister, the Attorney General responsible, said, well, the Landlord and Tenant Act is becoming a thing of patches. It's almost in shreds. It had been amended numerous times through the 1950s and 60s, and at this point was becoming a complicated, very much patchwork regime. We'll come back to that in a moment. This fellow, at this point in the seminar, you should be shouting out, look out behind you. This is Sir Garfield Barwick. On the Woolworths case, Whitlam was the junior barrister and Garfield Barwick was the senior barrister. Barwick was the leading Sydney barrister at the time. At the time of the decision, Whitlam had already become an MP. Barwick would shortly follow him to Canberra as MP for Parramatta, as a Liberal MP, and a prospective successor as Prime Minister to Menzies. And he became Foreign Minister, Attorney General, but he had a disappointing career in Parliament, and he got monstered in Parliament by Whitlam and other Labor MPs. Whitlam called him a truculent runt, which was very rude, and made Sir Garfield cry. And when his potential as a future Prime Minister started to become apparent and to wane, He got the consolation prize of Chief Justice of the High Court, and he was responsible for Rathbone and Abel, and also as Chief Justice, of course, he was also the unauthorised advisor to the Governor General, Sir John Kerr, in the dismissal. Second case about eviction controls, how eviction controls work under the New South Wales Planning 48 Act. This case is Women's Hospital at Holiday. It's a residential case. Whitlam again represented the landlord in this one, which was the hospital. In this case, the hospital, Women's Hospital at Paddington, had on its grounds a building that it let to a tenant, and the tenant operated that as a boarding house. I'm not completely sure, but it could have been one of these terrace houses in between the hospital buildings. And they'd let that to the tenant as to use as a boarding house. And sometime later, the hospital decided that one of the premises was going to use it as consulting. So this is a case about how tenancies ended under the 48 Act. Under the 48 Act, evictions were on only certain prescribed grounds and very narrow grounds. They included where the tenant hadn't paid rent or was in breach, but otherwise, they also included the landlord wanted to occupy the premises themselves, demolition, and use as a hospital was a prescribed ground under the 48 Act. Use as a vicarage was also a prescribed ground under the 48 Act. These grounds didn't include no grounds. They didn't include just selling the premises or getting the premises ready for sale. They didn't include no grounds and sale. They're the big differences from modern tenancy legislation. But also, hardship was a consideration in proceedings on all grounds. The court had to consider the balance of hardship between the parties. On some of the grounds, own occupation and demolition, the court also had to be satisfied that the landlord had made available alternative premises to the tenant. That's a major protection against eviction. Also, lodging houses were covered as well as other mainstream tenancies. Lodging houses. There was also another piece of legislation, the Landlord Tenant War Service Amendment Act of 1949. It had additional protections for a class called protected persons, and these were members and ex-members of the Defence Forces and their female dependents and parent dependents. And they had additional protection, particularly through accommodation requirements, alternative accommodation requirements that applied to additional grounds, including the hospital ground. So in this case, there was a question about the hospital made out the hospital ground under the 48 Act. They wanted to use it as hospital, but some of the residents of this boarding house were protected persons under the full service provisions. When it went to the Supreme Court held no. These are two separate pieces of legislation. So they might be lodges, and so covered by the 1948 Act under the provisions of, say, lodging houses. But under the War Service provisions, that doesn't talk about lodges. So that would provide additional protections to these people who are tenants, but they can't claim them as lodges. And these two things are separate. And so through that loophole, Whitlam's client walked and got their premises, got the hospital back, evicted the residents of the lodging house. And that was something that we closed by them. They brought the War Service provisions into and closed out. Another theme of the 48 Act, which should already be apparent from the two cases that I've discussed, is that it was complex legislation. And it also had a complex interaction with the common law. So it was not just what's in the Act, it's also the common law, all of the judge-made law that has been handed down in precedents from England forever. And a further example of this is the case of Killerby and Farthing, another residential tenancy case, and again, Whitlam's for the landlord in this one. This related to the interaction of tenancy law with matrimonial disputes, and in particular, in this case, a landlord was seeking an ejectment action, that's where they get their property back, where a tenant had purported to surrender the tenancy to the landlord, but they had in fact remaining in the premises was an ex-spouse or a deserted spouse in the language at the time. So tenant moves out and leaves behind a deserted spouse. So can the landlord get the premises back? This had come up in a similar case a year previously, in a case called Webb and Dieter. And in that case, a male tenant husband, deserted his wife. She was left in the premises, and the landlord wanted to get the premises back. And the court had held in that case there was no valid surrender of the lease by the husband when he deserted his wife. She could defend the ejectment proceedings as if the tenancy was still on foot, including having the landlord have to give grounds, those limited grounds for eviction, and whatever other protections might apply, alternative accommodation, all of that. However, in this case, in Killerby and Farthing, it was a bit different in that the tenant was a woman and she left her husband, and her husband back. And the Supreme Court held that is different. The wife can validly, it's different when it's men and women. A wife can validly surrender the tenancy. She doesn't owe a husband an obligation to keep a roof over his head, and it doesn't go the other way. There was also an argument by the husband that he still had a license. He had a license to be there, permission to be there, and that should be protected by an injunction given by the court. The court's like, I need an injunction because that's invoking our equitable jurisdiction, and you've just got a license on a beneficial interest in the property, so we can't do injunctions. So it gets done. So in this case, again, Whitlam's client gets their property back. As a tenancy law record, there are some tenancies saved. It's not all the story of the lodging house full of veterans that you helped evict. There are some tenancies saved, but no great social justice wins or losses for that matter. It's technical wins and losses in what is a complex area of law. Let's talk about Whitlam in Parliament. So in 1952, he's elected member for Werriwa at a by-election. And at this time, Werriwa was the seat of Werriwa was really big. It went from Cronulla in southern suburbs all the way to Liverpool. Whitlam lived at Cronulla. He actually was never a tenant during any of this time. He owned the house at Cronulla, having bought it with his war service home loan, and then bought the block of land next door with winnings from the National Radio Quiz competition that he entered. He was carryover champion for 2 years. Bought the block next door. So they lived at Cronulla, came at a by-election, becomes the local federal member. His maiden speech was on housing supply. It was all about how Menzies government wasn't doing enough in terms of the Commonwealth State Housing Agreement to build new housing under the Commonwealth State Housing Agreement, and how first-time buyers didn't have enough access to finance for home purchase. For someone who had by then spent 5 years in the company of landlords a lot of the time, it's remarkable that he didn't say anything about private rental being part of the solution to housing supply problems or housing problems in Australia. In 56, Werriwa changes its boundaries, and that eastern part, the Cronulla part, goes into another seat, and the Whitlams moved from Cronulla to Cabramatta, which is where Werriwa was centred on thereafter. His brush with tenancy law in Parliament as an opposition Labor MP in the federal Parliament was through this thing, which I've misnamed. It was actually the Anti-Eviction and Tenants Protection Committee. The Tenants Protection and Anti-Eviction Committee. This was set up in 1958 by another federal Labor MP called Eddie Ward, MP for East Sydney. And it had, it reflected a controversy that was taking place within the New South Wales State Labor government over rent and eviction controls, over the 48 Act. In 1954, the Labor government, the state Labor government, had decontrolled new dwellings. So new dwellings built from December 1954 weren't going to be subject to rent or eviction controls. And in 58, it adopted a Liberal proposed amendment and decontrolled dwellings that became vacant after a tenancy had been terminated on certain grounds. And this was very controversial because the apprehension was that landlords would harass tenants out of their tenancies, get their properties back, and get their properties decontrolled. So in response, Board establishes the Anti-Eviction and Tenant Protection Committee. And in doing so, he's evoking an historic memory, a powerful one. So anti-eviction committees had been set up a quarter of a century earlier during the Depression by unionists and socialists and unemployed workers as a direct action response to the eviction of unemployed workers. And these committees would picket properties. They'd warn off landlords and real estate agents. There's a couple of famous instances where there's physical conflict with police and bailiffs trying to take back possession of properties, and these committees taking the fight literally to them and trying to turn it back. They're a sort of a storied part of Australia's housing history, these anti-eviction committees of unemployed workers. Board's 58 committee wasn't quite as effective. It was pretty quickly wound up. So the state Labor Party denounced it. Whitlam, who plausibly was there to have a good chat about tenancy law, he quit it, and it was denounced as being this agitator front organisation that was just trying to disrupt the party and disrupt the conference. So Ward wraps it up with a call for nationwide rent control. But by that stage, new tenancies were decontrolled everywhere except for New South Wales. All the other states had made even further moves on decontrolling. And in fact, most tenants in Tasmania, Victoria and WA, most tenancies were decontrolled by that stage. So that their rent and eviction controls have been almost entirely rolled back by the late 50s. It took longer in New South Wales, but the momentum was building. So in 1960, there's a Royal Commission. The state Labor government flicks it to a Royal Commission that recommends the provision be almost entirely retrenched, so that only low-income households would have any resort to rent controls or eviction controls. Government changes in 64, 65. The coalition government had committed to no change in its first term, but then in its second term, it amends the Act in a big way with provision for market rents for people on moderate or higher incomes, reflecting the law, the Royal Commission recommendations. So market rents and a new ground for termination for wealthy tenants, known as the wealthy tenants ground for termination. And that really accelerated decontrol. In 1960, 2/3 of rental properties were still subject to controls, but it really accelerates, decontrol really accelerates over 60. Back to the Whitlam story. Whitlam would defeat Ward in 1960 for the position of deputy leader of the Federal Party, and 7 years later he goes on to defeat Caldwell, who became leader in 60. Defeats Caldwell to become leader in 67. And really the episode and Ward's decline from prominence, one of Whitlam's biographers has a line about Ward, fighting the old fights, just rehearsing old bouts from, and you feel like that's what the Tenants Protection Committee was about. While Whitlam, on the other hand, goes on to renew the Labor Party and its policy platform, and it's much more around expanding home ownership and expanding quality of life for a generation that had left rental housing and become homeowners in underserviced suburbs throughout Australian cities. So in government, Whitlam wins the 1972 election, ending 23 years of coalition government, with a program, ambitious program for social and economic reform and law reform. In relation to tenancy law, he also introduced rent control in the ACT and the Northern Territory, which at this stage they hadn't yet become self-governing at that stage. So rent control on a basic rents plus approach in the ACT and Northern Territory again, that's the least significant thing he did in relation to tenancy law. So rent control in those two jurisdictions really didn't last much longer than the Whitlam government itself, and isn't the most significant part of the story. The more significant parts are the Law and Poverty Commission and the Social Welfare Commission. They're more significant to what happens to tenancy law afterwards. So the Law and Poverty Commission, this had actually started in the final months of the previous coalition government, which had commissioned Ronald Henderson to inquire into poverty in Australia. Henderson has the poverty line named for him, but he was one researcher on a pretty narrowly focused poverty inquiry. When Whitlam comes to power, he expands the poverty inquiry to include additional topics, including law and poverty, with an additional commissioner, and that's Ronald Sackville, the fellow pictured there. He's, at the time, a UNSW law professor who looks more like one of today's UNSW law students. And he was charged with investigating both areas of substantive law, special significance to the poor, including tenancy law, and alternative forms of legal advice and assistance. They're both to the story. So that commission, Sackville's Law and Poverty Commission, engages another legal academic, Adrian Bradbrook, to do a substantial piece of research into the state of the law, state of landlord tenancy law in Australia at the time, after the rent control period and the decontrol that had been affected over the 50s and 60s. And he finds, echoing the description previously of the law being a patchwork or a shredded thing, that the state of the law isn't satisfactory to anyone, most law tenants, but it's a scandal, he says. So a really strong critique and strongly evidenced too through a substantial research report. Sackville in 75, in a report handed down on the 20th of October, and that's the anniversary that went unobserved, 50 years since the Law and Poverty Inquiry, Law and Poverty Commission report around makes a report that on law and poverty. And in the tenancy section, Sackville pretty much adopts Bradbrook's critique and recommends residential tenancy law reform across Australia on what will now seem a pretty familiar model. That's prescribed standard forms and terms, protection of tenants' bonds, prohibitions on fees other than rents and bonds, market rents. So getting away from rent control, which he said didn't have much to recommend it, but there is this idea that market rents are something that tenants should embrace. It's not a scary concept for Sackville. Instead, there's a concept of landlords unfairly increasing rents above the market level, and we can have provisions for tenants to challenge excessive rents and bring them back down to the market. Reasonable grounds for termination is something that was part of his model, and also specialist tribunals. So tenancy disputes not going to before the courts, but instead more accessible, cheaper, quicker, and less formal specialist tribunals for tenancy matters. And on legal services, he recommends the establishment of legal aid commissions or a legal aid commission. There was the Whitlam government had already sort of expanded the old Legal Services Bureau to cover more than just veterans. They were covering other social security recipients and other people with federal legal problems. But an expanded legal aid commission that would also provide funding to local legal centres where committees of local people would determine their priorities for legal spending and legal education and legal service. We'll leave that there, because 20th of October, when it presented its report to the government, was a pretty hectic time for the Whitlam government. It was dealing with a lot. So we'll leave it there for the moment. The Social Welfare Commission was another, it also started early in the Whitlam government. There was Marie Coleman was commissioned to administer, through the Social Welfare Commission, administer the Australian Assistance Plan, which was something that was part of the Whitlam program taken to the election. And this was a national experimental program to get people together to improve their community in the way they want. It would provide funds to community committees, community organisations to do a whole range of things that communities had thought were worthwhile. And so it funded a multitude of local community-based projects, like a lot of childcare centres and services for older people, and notably at South Sydney Community Aid, they funded a tenants' rights project, which produced the first fact sheets and the first tenants' rights manual. So after 75, the Whitlam government's dismissed in 75, loses the subsequent general election. And in 76, the Australian System Program is terminated. But not before, I mean, some of those organisations set up under the AAP continue to this day, having found funding from somewhere else. And also that tenants' rights project had helped in 76, it helps establish the tenants' union in New South Wales, which is still going on. In 77, that project, that proposal from Sackville for legal aid commissions gets taken up by the states, and state legal aid commissions with federal funding are established, and also a program of funding for community legal centres. Perhaps not quite on the scale that Sackville envisaged. Local community legal centres are responsive to local priorities and needs. There was also in New South Wales a bit of tenancy law reform, picking up a Sackville recommendation for bond protection. So establishing the rental bond board, tenants would no longer have their rental bonds held by the landlord, where it could mysteriously go missing at the end of the tenancy. Instead, they'd lodge their bonds with the rental bond board, a government agency, and interest on those bonds would be available for the funding of tenant services, which not immediately, but shortly afterwards would start to fund the tenants' union and tenants' rights. And then from 1978, the first state, South Australia, enacts residential tenancy legislation on Sackville lines, and then every other state and territory over the next 22 years does something similar. None of them completely reflected Sackville's recommendations. All of them allowed for no grounds terminations. All of them differed a little bit from each other, not just a little bit, differed from each other, but they were on this broadly common model that Sackville had recommended. So bringing the story up to date today, reflecting on residential tenancy law and practice today. So Residential Tenancies Acts on the Sackville model are now well established in all jurisdictions. They've been through, all of them have been reviewed and amended at different times. They're increasingly comprehensive in terms of tenancy law. So just about everything that happens in a tenancy that needs a legal response will be found in the Residential Tenancies Act rather than in the common law of property. Residential tenancy law is now mostly separate from property law and from commercial tenancies. And recently, some of those Residential Tenancies Acts have been improved as regards security. So no grounds terminations have been, just in the last couple of years, been abolished in 4 jurisdictions now. 1948 style rent controls are a thing of the past, almost. There are still some tenancies in New South Wales covered by the 48 Act. No one knows how many. It's certainly a tiny number, but they're still out there. And the vast majority of residential tenancy litigation is in the tribunal, the New South Wales Civil and Administrative Tribunal, and rarely do tenancy matters turn up in Superior. Correspondingly, there are very few specialist residential tenancy lawyers now in private practice. There are some barristers who still do it a bit, largely because they have an association or prior career or association with one of these other organisations. Almost all specialist residential tenancy lawyers are employed in community legal centres, such as the Tenants' Union, and in some of the state legal aid agencies. New South Wales has a housing law practice in its legal aid agency, but other states don't. Some of the states don't. Most of the work of tenancy legal practice is done by specialist advocates, and not all of them lawyers. In fact, most of them are not lawyers, in networks of local community organisations, tenants advice and advocacy services. There's networks of local services in most states, New South Wales, Queensland, Victoria, WA. And they're funded, they run on the smell of an oily rag. It's less than $20 per renter household per annum, and less than 10 in some jurisdictions. This is something that wasn't so anticipated by Sackville. So if Sackville set some lines along which tenancy law has developed over the last 50 years, what wasn't anticipated was the growth of private rent, relative both to owner occupation and social housing. So I'll conclude by saying 50 years on from the end of the Whitlam government, I'd suggest it's time for less accommodation of private landlords in law and policy, as we've seen over the last year. A coordinated research-backed residential tenancy law reform agenda at a national level, coordinating the states, and a substantial increase in funding for tenants advice and advocacy services in the service they do today. Thank you.
Right. Thank you so much, Chris. I wonder how there are still tenancies under 1948.
Yeah, there's still some, and they pop up in unusual places now. So, like I said, the 48 Act was its scope was increasingly rolled back by amendments in the 50s that said if it's built after a certain date, it's not going to be controlled. So that means still premises before that date might be controlled. And then later in the 50s, there was if the tenancy, if the premises have become vacant, and it's not a certain sort of other certain grounds on which they become vacant, then they could escape coverage at that point as well. So there were laws passed in the mid-80s that said there'll be no more new tenancies under the 48 Act created as of January 1986, I think it is. And in fact, the 48 Act was itself repealed in 2018. But when they repealed it, they tucked its provisions up the end of the Residential Tenancies Act and said for anything that's still out there covered by the Residential Tenancies Act, covered by the 48 Act, even though it's repealed, it's still subject to these provisions. And there was a case that came up last year. As I say, they're turning up in unusual places. So this was a guy who, it's up at Catherine Hill on the coast, and he was in a position where he thought he owned the house and rented the land underneath. There have been a few cases like this, where in these, particularly in regional areas, you might find that some business operates like a mine or a pottery that allows people to build houses on site, and there's been a sense of people trading their houses but paying rent to the company that owns the land underneath. And it's been established that those people don't actually own their houses, but in fact the leases of the land underneath with the houses on them could be protected tenancies if everything else lines up for them. So it's cases like that the Catherine Hill case, he went to the local court for his fair rent determination, and he pays $50 a month rent for his house in Catherine. So they're all of them are older people now, and also unusual cases, including just weird factual cases.
Where is world's international best practice in terms of tenancy law? It could be another lecture, I realise.
Yeah, there's good question. I mean, we used to say Germany, and there's something to be said for that. They do have rent regulation, not of this sort. You don't have to find out the rent in 1939. And there's and limited circumstances in which tenants can terminate. I think maybe there are, and there's a lot in the last few years. There's been lots of innovation around the world in rent regulation, new regimes for moderating rent increases, and again doing things differently from the complex and repressive method of the 1948 Act. But that said, I think, and we can learn from all of those international examples, but it's also about how law interacts with other policy settings in Australia, and I think that's how we best make the argument for law reform here. We can learn from other places, bringing examples, but we can also say this is a reform that will be practical and work with our current, with how the rest of the housing system in Australia works. So, for example, no grounds termination should be an easy. That was no grounds has always been too accommodative landlords. It sort of makes sense in the context of the Australian housing system, where there's lots of little landlords and they want to have a free hand in dealing with their property. But we can also make the argument that, yeah, we can get rid of no grounds and still provide for grounds for termination that don't upset the wider arrangements too much, but will still advance tenants' feeling of security. Or we could go further. We could start saying, well, we can push further into centering tenants and tenants' interests as the first objective of tenancy law. And it doesn't matter if we're accommodating landlords so much. We can raise the standard of security and other aspects of our tenancy law, other aspects of the renting experience. And if landlords don't like it, they can leave. And I think that's the sort of direction that we can be moving in our discussions about tenancy law, rather than just accommodating the landlords, but starting to think about how we can use tenancy law as part of a wider reform of the housing system.
Thank you so much, Chris. Thank you everyone for joining us today. Just a quick reminder that our next seminar will be held in 2 weeks, and we're going to hear from Dr. Mariam Sonara and Dr. Lee Roberts on Are We There Yet? Modeling National Cycling Patterns to Reveal Australia's Policy Implementation Gap.